Hello, everyone. My name is Alian Jaffrey, and my topic is the evolution of the 14th Amendment. Since its ratification all the way back in 1868, the 14th Amendment has seen tremendous progression in terms of the expansion of rights for everyday Americans. Started off as granting citizenship to formerly freed slaves and equal protection laws. The 14th Amendment over the last 152 years has evolved into one that has guaranteed gay rights. It's given rights to privacy, among others. So I wanted to see what influences the evolution of this 14th Amendment, how the change of interpretation has evolved all the way back in 1868 to present day, as recent as 2015 with Obergefell versus Hodges, which granted gay rights. To do that, in my research, I was expecting to identify the causes for this change of interpretation by the Supreme Court and argue that the court used the 14th Amendment to adapt to changing social, political, and economic circumstances brought on by a modernizing America. Speaking of a modernizing America, the 14th Amendment today, using Section 1's equal protection, due process, and privileges and immunity clause, has guaranteed equal rights for all Americans, regardless of race and gender. It's legalized same sex and interracial marriage. It's legalized abortion under certain conditions. And previously, it segregated the country, but it also desegregated the country about 50 years after the segregation laws. But more importantly, how did we get here? How have we got all of these rights? Well, the original intent of the 14th Amendment was only to grant citizenship and equal rights for newly freed Americans who were no longer classified as three-fifths of a person, at least in the eyes of the law. Congress actually passed the amendment to redeem the country from the awful Dred Scott decision a few years back, which is widely considered one of the worst Supreme Court decisions in American history. Passing the 14th Amendment, however, wasn't that easy. It was on the back of the Civil War. The 13th Amendment was passed in 65, and 3 years later in 68, Congress was looking to pass the 14th Amendment, which raised major objection from Southern legal experts and Southern states. But in order to get back into the Union, they had to ratify the 14th Amendment, leaving them with no choice but to object. The actual first instance of the 14th Amendment being used by the Supreme Court in a ruling was seen in the slaughterhouse cases. The slaughterhouse cases originated in the state of Louisiana, where the state government decided to monopolize the slaughterhouse business af- and hand the ownership all the way to one company. Obviously, every other business within the slaughterhouse industry objected to this and took their issue all the way up to the Supreme Court. However, because the 14th Amendment was not used previously, the decision, regardless of who it was for by the Supreme Court, it would have been an unprecedented decision. And so the Supreme Court decided to stick to the strict interpretation of the 14th Amendment by claiming that it was only to grant citizenship to former slaves, and it ruled against the businesses who took it up to the Supreme Court. Another instance of the Supreme Court limiting the rights of Americans was seen in Plessy versus Ferguson, which basically encouraged Jim Crow laws and segregated the country further on. Now, these are some notable Supreme Court cases, which have mostly, for the most part, expanded upon the rights of Americans through the 14th Amendment. You can see in Gideon versus Wainwright, Griswold versus Connecticut with the right of privacy, Loving versus Virginia with the interracial marriage, Birchfield versus Hodges with the gay rights. So let's start off with segregation. In Plessy versus Ferguson, the Supreme Court established the separate but equal doctrine, which encouraged more Jim Crow laws to take into place. It was a strict interpretation of the 14th Amendment, and it was a very overwhelming 7-1 decision against Plessy. Now, the reason it was so easy for the Supreme Court to have such a practically unanimous decision was because the attitudes of the people within the country was aligned with the Supreme Court. People wanted to be separate, at least those in power, those in majority. And they didn't want African Americans, for the most part, in terms of the minorities, to be a part of their neighborhoods, to be a part of their buses, to be a part of their area. They wanted minimal interaction. However, about 50 years later, when the African American movement, the civil rights movement, took up steam, you've gone through two world wars, you've gone through a Great Depression where African Americans showed how valuable they are. With the Harlem Renaissance, you can see what they bring and contribute to the country in terms of culture and history. So, in the Brown versus Board of Education decision, it overturned the Plessy versus Ferguson decision and removed the separate but equal doctrine. It was an influential case for civil rights because only 10 years later, the Civil Rights Act was passed. It was a pretty much unanimous decision because the Supreme Court reflected the people in America. People wanted change. People wanted to get rid of segregation. Now, moving on to the right of privacy. In Griswold versus Connecticut is where the Supreme Court implied that there was a right to privacy in the 14th Amendment, because it's nowhere explicitly written in the Constitution that there is a right to privacy. So this was a precedent that was used in Roe v. Wade, where the right to abortion under certain conditions, I believe, which is the first trimester, um, it basically said that the privacy rights to an abortion are part of a woman's liberty, which is guaranteed in the 14th Amendment, that, my pursuit of liberty being infringed upon if you take away my rights to an abortion. So as you can see, Supreme Court in 65 and 73, you again, it's more of a reflection on the people, on society in general. Had the case been brought up about 50, 60 years ago, even, it wouldn't have possibly had the same favorable decision. The only reason it did was because the women's suffrage movement in 1919, with the rights to vote, with the amount of domestic involvement they had with the two wars, um, women were getting back and were starting to get into the workplace. So all of this contributed to a more liberal, loose character, going away from traditionalistic norms that women were previously viewed as. Now, interracial marriage was actually a very big blow to segregation. So even though the Civil Rights Acts were passed in 64, segregation was still there, at least not by law, but culturally and in the attitudes of the people for the most part. So it struck down anti-misogynist laws, and it was a very unanimous decision again, because again, the country was moving towards a more progressive mindset. Race one was more about inclusion than diversion, which had previously been used as an angle to divide the country further on. Now, one of the most recent cases only 6 years ago was seen in Birchwell versus Hodges. It guaranteed rights to the LGBT community. It was actually an umbrella case which covered six lower court cases of six gay couples suing each of their states, which banned same sex marriages. Now, crucially for Birchwell versus Hodges, it was in the age of social media. I distinctly remember seeing the case trend on Twitter, on Facebook, for and against. It was a very divided topic, and a point of contention, which can be seen or reflected upon in the tight 5-4 decision in favor of Birchwell. So the country was very divided on the case. You have the largely Christian right against the largely liberal left. So thankfully, the 5-4 decision did play in favor of Birchwell, and it guaranteed same sex marriages. And it was a big win for the LGBT community. And let's talk about uh, the evolution of the 14th Amendment from the point of the first case all the way up to one of the most recent cases. As you can see, initially, the 14th Amendment was very strictly interpreted by the Supreme Court. You can see with 1873 cases of slaughterhouse cases where state regulation of business does not violate the 14th Amendment, according to the Supreme Court. Even in 96 with the Plessy versus Ferguson decision, which basically said the Jim Crow laws are accepted as constitutional. So up till then, it was a very fair reflection of society in general. People were kind of okay with segregation. They were okay with not considering the Supreme Court as limiting the rights through the 14th Amendment. It was after two world wars where America went from a pretty much isolationist state to one of the biggest world powers in the world, where inclusion, where almost the domestic issues were being sidelined or not as important as the international affairs, which allowed for people to come together. With the two world wars, it didn't matter if you're African American or you're white. Sure, they were segregated within the armies, but pretty much they had a common enemy for once, and the enemy wasn't each other. You can see with 54, with the school segregation being found unconstitutional, with the Roe v. Wade decision in 73 protecting a right to privacy, obviously with Griswold versus Connecticut setting the precedent for that. In 67, with laws prohibiting interracial marriages being unconstitutional, which allowed for more inclusion within society. It allowed for a little bit less divided communities as far as a white community and African American community, and separate minority communities. It allowed for more inclusion, more blending in. And finally, you can see with the fundamental right to marry extends to sex couples that are the same sex. So the 14th Amendment has distinctively improved upon in terms of the interpretation, guaranteeing more rights as the years have passed. And it's a fair reflection of how society in America has progressed. America is not the same as 10 years ago, let alone 100 years ago. And the Supreme Court, for the most part, has based their decisions upon the reflection of American society in general. These are my works cited, and thank you.